Check 1 2, check 1 2. All right, Ms. Aslan, would you like to make an opening statement on behalf of the staff of the commission?
Good morning. May it please the commission. My name is Casey Aslan, and I am representing
Ms. Aslan,
commission
would you like to
staff.
make an opening statement on behalf of the staff of the commission? All right. Again, if there are people on WebEx, please mute your feed.
The primary question before you today. My name is Casey Aslan, and I am representing commission staff.
Opening statement on behalf of the staff of the
I don't
commission.
know, I've never had that before, it's just, I don't know what's going on. I can-
Is it,
All right, again, if there are people on WebEx, please mute your feed.
The primary question before you today, my name is Casey Aslan, and I am representing commission staff.
I'm going to make sure,
Put my tea guy again, I don't know what's going on with that. Haven't known. There's a ghost in here today. Can't turn that on.
Okay.
Is it, all right?
I'm gonna make sure
again,
it's
if there
not
are people
me.
on WebEx, please mute your feed.
Is your WebEx up?
my WebEx isn't up, but
Primary question before
the
you
website
today.
feed is, and I'm just now seeing that it's not on mute.
I am representing commission staff.
Yeah, no, it's.
I want to make sure.
That's great. Like, mine shouldn't be on.
Well, what I'm saying is, it's on mute now.
Is it, all right?
I'm going to make sure it's not me.
WebEx, please mute your feed.
My WebEx isn't up, but the website feed is, and I'm just now seeing. We are. So, let's go off the record.
So it should feedback then again, if that's the case. Check 1, 2, check 1, 2.
All right, let's go back on the record. And if you don't mind, Ms. Aslan, let's start from the top.
Okay. Good morning. May it please the commission. My name is Casey Aslan, and I am representing commission staff. The primary question before you today is whether or not to defer $31 million of FAC fuel and purchase power costs to a subsequent general rate case. There are several reasons that such a deferral should not be granted. First, the Commission should not consider the Fuel Adjustment Clause, or FAC, rate adjustment mechanism's requirement that fuel and purchase power costs will be rebased in Evergy's current general rate case to determine the amount of the deferral in question. According to Section 393.1655 Sub 3 RISMO, the computation of plant in service accounting, or PISA, shall use the Electrical Corporation's average overall rate as of the date new base rates are set in the Electrical Corporation's most recent general rate proceeding concluded prior to the date the Electrical Corporation gave notice under 393.1400. While some stipulations have been approved in Evergy's current rate case, the Commission has not yet issued an order on issues that were litigated. Most importantly, new base rates will not be in effect until December 6th of this year. Second, allowing for recovery of the full fuel and purchase power adjustment, or FPA, for the 30th FAC accumulation period without deferral will not cause the company's overall rate to exceed the 3% annual growth cap set forth in Section 393.1655.3. Third, the company has presented testimony that the costs incurred during the 30th accumulation period are extraordinary due to the ongoing pandemic and Russia's war on Ukraine. Unfortunately, increased fuel costs are currently the norm for all utilities, not just Evergy Missouri West. It is also worth noting that Evergy Missouri West's 29th accumulation period had an FPA of over $47 million, which is nearly $3 million higher than the current accumulation period. To staff's knowledge, Evergy Missouri West did not present an argument that the FPA from the previous accumulation period was extraordinary. This case, like many before this Commission, involves a confusing combination of industry acronyms, dense statutory language, and my least favorite, mathematical calculations. However, the issues involved can be simply restated. Should the Commission approve a deferral that is not extraordinary, does not meet statutory requirements, and would cost ratepayers more money if approved? The answer is no. Staff witness Brooke Mastroiannis is here today to testify and answer any questions you may have relating to this case. I'm also happy to answer any questions to the best of my ability. Thank you.
All right. Are there any questions from the commissioners?
No questions, Judge.
And could you identify yourself, please?
Sure, this is Chairman Sylvie.
All right. Thank you.
This is Commissioner Holzman.
All right.
Commissioner Kochmeyer's here.
All right, Mr. Kleiser, would you like to give an opening statement?
I've been informed that I don't have control over the PowerPoints. You're going to hear me saying forward a lot. Just ignore that. Whenever you're ready. If it would please the Commission, John Kleiser, on behalf of the Missouri Office of the Public Counsel. Forward. There was a lot of information provided by counsel for both Evergy and staff. In my opinion, this is a very, very simple case. It's a case of basic statutory interpretation. And the question in front of you really has to do with the application of a single statute. Forward, please. That is section 393.1655 sub 5, or point 5. And the question for the Commission is quite simply, has that provision been triggered? Forward. If it has been triggered, then you are free to fine for Evergy. And if it has not been triggered, forward, you should be fining for the staff and the OPC. So let's take a quick look at the actual language itself. Forward, Brian. Forward again. The triggering mechanism in question states, if a change in any rates charged under a rate adjustment mechanism approved by the Commission under sections 386.266 and 393.1030 would cause an electrical corporation's average overall rate to exceed the compound annual growth rate limitation set forth in subsection 3 or 4 of this section, etc. Now, this is what I refer to as the triggering mechanism, which means this is the condition that needs to be met legally before any deferral takes place under this provision. So we need to first determine whether or not this triggering mechanism has been met. And in order to do that, let's take a moment to break down some of the terms in this statute to provide a clearer understanding of what's going on here. Forward, Brian. So let's start with some translation. Forward again. Let's start with the phrase, a rate adjustment mechanism approved by the Commission under Section 386, 266, and 393.1030. Forward. This, in essence, is the FAC, or Fuel Adjustment Clause, and the RESRAM, or Renewable Energy Standard Rate Adjustment Mechanism. Forward. 386.266 is the FAC. Forward. And 393.1030 is the RESRAM. So, forward again. If we return to our statute, we can basically plug in the FAC and RESRAM for that part of the section. Forward, please. Which you can see I've done here. Also, just to make things easier, we can replace Electric Corporation with Evergy West, since that's the only electric corporation we have in this case. Forward, please. Now, let's translate a little bit more. Forward again, please. Forward again. The second part that we're talking about is the compound annual growth rate limitation set forth in subsection 3 or 4 of this section. Now, which subsection applies is dependent on when exactly the company elected for PISA deferral. In this case, there's no dispute that the company elected for PISA deferral at such a time that subsection 3 would apply. Forward again. So we know that it's subsection 3 that applies. Again, not in dispute. And as a result of that, the compound annual growth rate limitation is 3%. Forward again, please, Brian. So if we go back to our statute and we plug in 3%, we can see that it changes as thus. Forward again, please. This is the translated effective statute in question that we need to be interpreting. If a change in any rates charged under Evergy West's FAC or RESRAM would cause Evergy West's average overall rate to exceed the compound annual growth rate limitation of 3%. So based on that, the big question before us is rather simple. Forward, please, Brian, and then forward again. Does inclusion of the full amount that Evergy West stands to collect in this FAC case cause their average overall rate to exceed the 3% compound annual rate growth limit? Forward. And the answer is no, it does not. No question of that. Let's walk through exactly how we get there. We need to do 3 things. We need to first just consider what's the amount to be collected, then figure out what percentage increase that will result in, and then compare that to the 3% compound annual growth rate limit. We'll do all of them in turn. It's very simple. Forward, please, Brian. Let's start with what is the amount to be collected. Forward again. I want to introduce a term to you, FPA. That stands for Fuel and Purchase Power Adjustment. That is a defined term in the Commission's FAC rules. It is defined as, forward, Brian, the dollar amount intended to be recovered from or returned to customers during a given recovery period for the FAC. So that's the amount you're collecting through the FAC. Forward, please, Brian. In this case, it's $44,604,020. That's for accumulation period 30, the current accumulation period. And we're going to round that, forward, Brian, to just $44.6 million. And you will note that that is the exact same number that you saw in Evergy's opening. Again, no dispute. Forward, please, Brian. So, what is the percentage increased average overall rates if that $44.6 million is fully recovered? Forward, please. The answer is a total of 9.14%. If you include all of the current base rates, the current RESRAM, and both the prior and current FAC accumulation periods, current in this case being the one at question here, the total increase is 9.14%. Forward, please, Brian. And this is taken directly from Evergy West's own work papers. I want to stress this point. Forward, Brian. This is a copy of the work papers, and I appreciate that it's probably a little bit difficult to read from where you're sitting. Forward, please. You can see here that we have the base rates, the RESRAM, and the FAC for both the 29th and 30th accumulation period. Forward, please, Brian. And the amount in total to be collected for the 30th accumulation period you can see is $66.4 million. Forward again. And the end result again, 9.14%. So there's no question that that is the percentage increase if the full amount of the FPA for this accumulation period is collected. Forward, Brian. So we have to come to the third and final part of the question. Does that 9.14% exceed the 3% compound annual growth rate limit? Now, what that 3% compound annual growth rate limit is depends on when you look at it. I'm going to give you 4 possible dates. Forward, please. The first is September 1st. That's the date that rates would have gone into effect for the FAC rate case had nothing happened. At that point, the CAGR limit was 11.69%. Forward again. As of September 21st, the date that we filed rebuttal testimony, it was 11.87%. Forward. As of December 1st, the date that we're asking the Commission to ensure that new rates for the FAC case goes into effect, it will be 12.51%. Forward again. And as of December 6th, the date that rates will become effective in the general rate case, it is 12.55%. Forward again. What is important and obvious here is that at no point, under no circumstances, does that 9.14% exceed the 3% compound annual growth rate limit. Forward again. So we can reach our conclusion, and it's very simple. As we've already seen and established, forward, Brian, the inclusion of the full amount that Evergy West stands to collect in the FAC rate increase case in this proceeding does not result in a change in the a change to Evergy West's overall average rates that exceeds a 3% compound annual growth rate limit. Forward again. And what's more important, all the facts that we can use to determine this are established exclusively by the evidence provided by Evergy West. This, in essence, was the reason why the OPC sought summary determination. But there's still some confusion. Go ahead and forward again. It brings us to the important question, why are we here today? If it's so obvious that we're not going to hit the compound annual growth rate limit, what has gone wrong that caused all of us to be here in this courtroom today? Forward again. And the simple answer is that Evergy West is committing plain legal error. Forward again, please, Brian. And that plain legal error is that Evergy West is attempting to include amounts that would be collected in base rates through a future general rate case in its calculations for the effect of changing the FAC charge in this case. Now, I say plain legal error, there are actually 2 errors we need to consider. The first, forward, Brian, is that a future general rates are not included in determining the effects of an immediate FAC rate increase. And the second, forward, Brian, is that a change in base rates is not a change in the amount to be charged under the FAC. I'm going to walk through both of these relatively quickly. Forward again, please. Now, the first error is rather self-explanatory. Forward again, Brian. Evergy West argues that changes in the current FAC rate would exceed the 3% compound annual growth rate limit because it's including what will happen in a future rate case. Forward again. There is no legal support for this position. Absolutely none. Forward again. More importantly, this is and will result in an arbitrary determination by the Commission. And why will it be arbitrary? Well, I posed to you a simple question. Name one other FAC rate increase case where future rate increases has been considered as part of this determination. It has never been done before for Evergy West, nor Evergy Metro, nor Ameren, nor Empire. And there's no reason to expect it to be done again otherwise. In other words, Evergy West is asking for unique circumstances applied exclusively to this case without legal support. That is the definition of arbitrary. But there is an even greater problem at play here. Forward again, please. And that's the second error. I'd like to bring us back to the language of the statute that we're applying here. Forward, please, Brian. And most importantly, I'd like to draw your attention to the phrase charged under. Forward, please, Brian. It is exceptionally important that you understand that this mechanism only applies if the rates charged under the FAC, or RESRAM, would cause the increase over the annual growth rate limit. Forward, please. Amounts charged under the FAC, however, does not include the amounts that would be collected for fuel and purchase power through base rates. Let's walk through legally why that's the case. Forward, please, Brian. Forward again. The FAC charge is a defined term in the FAC rules. It is defined as the amount on bills which in the aggregate will be allowed to recover the FPA, which I remind you is the fuel and purchase power amount, or adjustment, apologies. The FAC charge is also, quite obviously, the amount charged under the FAC. There's no dispute about that. Now, forward again, Brian. The FPA, as we've already discussed, is the amount to be collected, but how is that amount determined? Well, it primarily reflects the difference between the actual net energy costs and the net base energy costs during the accumulation period. Forward again. And the net base energy costs are the amounts included in base rates. So to demonstrate this visually, forward please. Consider a graph. Forward please. We start with the net base energy costs, forward. That is what's included in base rates. Then you look at the actual costs incurred, forward again. You take the difference of these two, forward please, and that amount, the difference, is the fuel and purchase power adjustment. Forward. Now, why am I harping on this? Why is this so critically important? Well, let me walk you through it. It's a very simple argument. Forward, please. If the FAC charge is the amount designed to collect the FPA, forward, and the FPA is the difference between the actual fuel and purchase power costs and the amounts for fuel and purchase power included in base rates, forward, then fuel and purchase power found in base rates cannot be included in the FAC charge itself. Again, the FAC charge collects the difference. It doesn't collect the amount included in base rates. And, as we've already established, the statute only applies if it's a change to the amount being charged through the FAC that causes you to trigger the cap, nothing else. So when counsel for Evergy tells you it doesn't matter whether or not it's the FAC or base rate fuels that cause you to go over the amount, they both have to be deferred, that is completely wrong. Legally speaking, only the amount collected through the FAC itself can possibly trigger the deferral mechanism. Forward again, please, Brian. And what we see here is that, forward again, Evergy West is trying to rewrite the PISA legislation. Forward, please. Returning to what the language actually says, as I just stated, it's the rates charged under the FAC that cause you to go over the cap to trigger this provision. What Evergy West wants to do, forward please, is include an entirely new provision in this statute that would add on the amount to be included in base rates in a future case. This, again, has no legal support. It requires a complete rewriting of the rule. And I just want the commission to consider for a second. Imagine if this case were brought up on appeal. Let's assume for a second that the commission decides to agree with its own staff and OPC, and Evergy brings the appeal. All the commission has to do is stand up and say, we followed the statute exactly as it was written. We followed our rules exactly as they were written, and we applied the status quo. And then what's going to happen? The court will quickly affirm. Easy. But what happens if the commission agrees with Evergy and the OPC brings the appeal? At that point, the commission is going to have to explain how, when calculating the amount charged under the FAC, it included costs that literally are not charged under the FAC. It's going to have to explain why it didn't follow its own rules and their definitions. This makes no sense. The commission needs to apply the law as written and consider only the costs charged under the FAC itself, which does not include fuel and purchase power recovered through base rates. I want to move on to one final argument. Forward, please, Brian. This is what I would characterize as the sort of Hail Mary argument by the company, who, realizing that their legal argument may not be the best, has decided to also try and argue that the costs must be deferred because they are extraordinary. Forward, please, Brian. That is simply not the case. Forward again. And more importantly, these costs are not extraordinary whether considered on an Evergy West individual basis or when considered in compared to its sister utility, Evergy Metro. Forward again. And I want to stress this point. This is very important. This case has absolutely nothing to do with Winter Storm Uri. Winter Storm Uri occurred in February of 2021. The accumulation period for this case is December of 2021 through May of 2022. There are no Winter Storm Uri costs involved in this case, flat out. Now, why is this not extraordinary when considered based just on Evergy West. Forward, please. The simple answer is that if you look at the fuel and purchase power adjustment for Evergy West's last accumulation period, it was $2.9 million, or 6.1% higher than the FPA in this accumulation period. Forward, please. What that means is that Evergy West actually recovered more costs in its last accumulation period, but made no attempt to declare any of those costs extraordinary. And that, at heart, demonstrates what the company's true position as to these costs being extraordinary is. Forward, please. Evergy clearly does not consider that the costs that it incurred extraordinary, and would not have made that argument but for its fear of hitting those statutory caps in this case. Their own past practice dictates their true beliefs. Forward again. But what of Evergy Metro, and why do I bring it up? Forward again, please. Evergy Metro did not ask for a deferral of extraordinary costs, even though it experienced the exact same high fuel and purchase power costs over the same 6-month period. Forward, please. In fact, according to the OPC's calculations, Evergy Metro's fuel costs were $105 million, 4 times what Evergy West incurred. Forward again, please. And its purchase power costs were nearly 13% of Evergy West's. Forward, please. That raises an interesting question. Forward, please. Why is it, oh, I forgot to mention, sorry. Even though its costs were so much higher, Evergy Metro's FPA for its accumulation period was less than $2 million. That's what raises the interesting question. Why is it that Evergy West's Metro's FPA is so much lower than Evergy West's if both companies are experiencing the same high fuel and purchase power costs? Forward, please. The answer is that Evergy Metro has generation where Evergy West doesn't. I want to be clear. I'm not saying that Evergy West doesn't have generation. I'm saying that Evergy Metro has substantially more generation. And as a result, it can sell its generation into the market to offset the fuel and purchase power costs it incurs. Evergy West, by contrast, doesn't have that capability. But that means that the high fuel and purchase, FPA costs that it's experienced for this accumulation period aren't the result of high fuel and purchase power costs, which Evergy West is experiencing. Metro is also experiencing. Evergy West's high FPA is the result of its lack of generation. Forward again, please. Forward one more time. And that lack of generation is the product of Evergy West's management decisions. This is not, again, the result of events beyond Evergy West's control. Evergy Metro experienced the exact same phenomenon that Evergy West did, but it was able to keep its FPA low. The only difference between these companies that really matters in this case is the amount of generation, and that's a decision that Evergy West's management made. Frankly, it's actually the management of both companies, or the same company. But regardless, the point here is that it's entirely within the control of Evergy West to manage its FPA by securing generation to offset its fuel costs like its sister utility. It chose not to. That's its choice. It's not extraordinary. One last slide. I want to leave the commission with one last thought. Forward, please, Brian. The OPC and the staff of the commission is not asking for any disallowance in this FAC case. I want to stress that. Forward, please. What we are requesting is for Evergy West to be made whole, to receive all of the amount that it needs for its FPA, and to receive it as quickly as possible. I want you to consider the implications of that. You have the consumer advocate for the state standing up here and telling you, please make the company whole as fast as possible. On the other hand, the company, forward please, Brian, is telling you that it doesn't want to be made whole as fast as possible because it's trying to avoid statutory safeguards that were put in place to protect consumers. This is a violation of the status quo. It is contrary to the written language of the law, and the commission should not accept this. Forward, please. To do what Evergy West is requesting would require this commission to go above and beyond, out of its way, to avoid the status quo and rewrite the law in a manner that would help the company and harm customers. I urge you not to do this. This is the one case where the OPC is telling the commission, follow the exact written language of the law. Do what you have done in every prior case. Make the company whole. Give them every cent of what they need and do it as quickly as possible. There is no reason why the commission should not take that action. The OPC has a single witness today, Ms. Lena Mantle. She has been instrumental in helping to draft the FAC rules when they were first written, and I think I can probably say knows them better than anybody else in this building without too much hyperbole. I encourage you to ask any questions that you might have of this to her. She is an excellent resource. And with that, I will ask if there are any questions from the commission or bench.
Right. Mr. Kleiser, before we get to that, and I apologize if you did do this, but for the sake of housekeeping and the court reporter that has to transcribe this, did you spell out what RESRAM stands for?
I did, but I will happily spell it out again. It is the Renewable Energy Standard Rate Adjustment Mechanism. And I just want to make clear, I feel like this is obvious, but this case does not concern any effect to change the RESRAM, so as it applies, it is not relevant to this case. I don't believe any party would dispute me on that point, other than that it has to be included in the average overall rate calculations, which it has been per everyone's assumptions.
Gotcha. All right. Are there any questions from the commissioners?
No questions from Chair.
No questions, Judge. No questions, Judge. Commissioner Holzman.
Okay. All right. Thank you, Mr. Kleiser. All right. Evergy, Missouri West, call your first witness.
The company calls Lisa Starkeybaum.
Good morning, Ms. Starkeybaum. Will you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give today in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. Go ahead, Mr. Steiner.
This is Roger Steiner speaking. Would you state your name for the record, please?
My name is Lisa Starkeybaum, Starkebaum.
Where do you work and what is your position there?
I work in Kansas City, Missouri. My address is 1200 Main Street, Kansas City, Missouri, 64105, and I am a manager of regulatory affairs.
Did you cause to be filed in this case direct testimony, which has been pre-marked as Exhibit 2?
Yes.
Do you have any changes or corrections to that testimony?
No, I do not.
If I asked you the same questions that are contained in that testimony, would your answers be the same today?
Yes, they would.
Are your answers true and complete to the best of your knowledge?
Yes.
Your Honor, this witness does not have live surrebuttal, and so I guess I'll wait to move the admission of the direct until after cross, or I can do it now.
Well, let's do it now.
I move for the admission of the direct testimony of Lisa Starkeybaum, Exhibit 2.
All right. Are there any objections to the admission of Exhibit 2? All right. Seeing none, Exhibit 2 is admitted. And I'll ask counsel, would you like Ms. Starkeybaum to remain here for possible cross-examination later?
I have no questions.
I have no questions as well, if the bench and the commission doesn't.
All right. Are there any questions from the commissioners? All right, hearing none. I do have a few questions myself. Can I direct your attention to page 7 of your direct testimony?
Your Honor, at one time you did say that all the witnesses were going to go up and then have cross afterwards.
That's fine if that's...
But I'm fine with doing it now if that's, I just wanted to let you know that it's a little bit different than what we were thinking, but she does not have live surrebuttal, so we could do cross now, that's fine.
that was all I had in mind, was she's kind of an exception to the rule, I think, for today.
Okay. That's fine.
Okay. So on page 7 of your direct testimony, lines 17 through 20, you compare accumulation period 28 to accumulation period 30. Would accumulation period 28 have covered the period of December 1st, 2020 through May 31st, 2021? That time period of Winter Storm Uri?
Yes, it would.
Okay. When you state that the actual fuel and purchase power costs in accumulation period 30 were $40.5 million higher than those in accumulation period 28, did you exclude the over $288 million that Evergy Missouri West has sought securitization for in case number EF-2023-0011?
Yes, all Winter Storm Uri costs have been removed in each FPA that we have filed since February, since the storm occurred in February of 2021.
Okay.
So those would be excluded.
Would you agree that if Winter Storm Uri related fuel and purchase power costs had flowed through the FAC, AP 28 actual costs would have been substantially higher than the actual cost in AP 30?
I would agree with that.
Okay. All right. Excuse me. Does staff have any cross-examination based on my questions?
No, Judge.
How about public counsel?
Just really quick, just so I have the dates. AP 28 is December 2020 through May 21st, sorry, May 21,
That's correct.
2021.
Correct.
And then AP 29 is, I assume, May 21 through December 2021, or?
June 2021 through November
Okay.
2021.
Okay, so it goes up to the start of the next month after the end of the first one.
Yes.
Gotcha. That was my only question. Thank you.
All right. Mr. Steiner, any redirect?
Could I have a moment, Your Honor?
Sure.
I have no redirect, Your Honor.
All right. Are there any questions from the commissioners as a follow-up to my questions?
No questions, Judge Holzman.
All right. Ms. Starkeybaum, you're excused. Thank you.
Thank you.
All right, Mr. Steiner, call your next witness.
Judge, at this time, we would call Darren Ives to the stand.
All right, and for the sake of the record, that was Mr. Fisher.
Yes, I'm sorry. Yes, Mr. Fisher.
All right, Mr. Ives, would you raise your right hand? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Mr. Fisher.
Please state your name and address for the record.
My name is Darren Ives. My address is 1200 Main, Kansas City, Missouri.
Are you the same Darren Ives that caused to be filed in this case direct testimony addressing fuel cost and PISA deferral issues?
I am.
If I were to ask you the questions that are contained in your written testimony, would your answers today be the same, and are they true and accurate to the best of your knowledge and belief?
They would be the same, and they are. I do have one correction.
Okay, I forgot to ask if you had a correction. Please state your correction.
Yes, it's in my direct testimony, page 5. And it's actually footnote 6 at the bottom of that page where I reference an EIA Today and Energy report. The date listed in my testimony is July 16, 2022. That report was actually dated June 16, 2022.
With that change, would the remainder of your testimony be correct and accurate, the best of your knowledge and belief?
Yes.
Judge, with that, then I would move for the admission of exhibit number 1, and we do, well, I'd move for the admission of exhibit number 1.
All right. Is there any objection? All right. Seeing none, Exhibit 1 is admitted.
We do have some additional live sir rebuttal that we'd like to present to the commission at this time, if that's appropriate.
All right. Yes, go ahead, Mr. Fisher.
Mr. Ives, did you read the rebuttal testimony of the staff and public counsel witnesses in this case?
Yes, I did.
What is your overall response to their testimony?
Yeah, my response, and it's the same response that I would have to the opening statements today, is I think both parties take a very narrow view of how to look at this case. They don't consider the rebase component of the FAC requirements and the implications of that. It puts the commission in a position where there's, between this case and the rate case, there's very little information advanced on what to do with what are very significant fuel impacts, not only from the 2 accumulation periods, but also from the rebase and how it interplays with the PISA statute.
Do you agree with the staff and public counsel's interpretation of the PISA statutes as they've expressed it in those witnesses' testimony?
No, again, I think, it's looked at too narrowly. You can see it best in staff's testimony. They reference the FAR, so that's the fuel adjustment rate filing, which is another term used for the filing that addresses the accumulation periods. And the FAR is accurately depicted in the testimony, but that ignores the remainder of the FAC requirement, which is the implication to rebase, the requirement to rebase in any rate case that you come in while you have adopted the fuel adjustment clause, and at a minimum, at least every 4 years, which is the cycle that we're on in this pending rate case. And I think by ignoring that, the real implication would be if you don't get the base rate right when you're doing a measurement, then you're going to have implications to the future FAR filings. So they are absolutely related and part and parcel to each other under the FAC requirements. And I think, ignoring that and trying to look at these cases in isolation is going to take us afoul of the intended purpose of the PISA legislation, which was to remove the effects of the rate adjustment mechanisms like the FAC from consideration of a performance penalty in meeting the compound annual growth rate.
On page 4 of the rebuttal testimony of staff witness Brooke Mastriani, and let me spell that name, it's Mastroginnis, and I apologize if I've mispronounced it. But
Fisher.
Yes.
I believe you've actually misspelled it.
Oh, I'm sorry. Did I miss? Mastrogiannis. Okay, I misspelled it. Sorry. I apologize. Anyway, if you turn to page 4 of her rebuttal testimony, she states that it's the staff's position that the 3% average overall rate cap computation required by PISA prohibits using the amount of the proposed rebased fuel costs in the current general rate case. Do you agree with that staff position?
No, I don't, and maybe now's a good time to talk about it, because I was a little bit confused when I read staff's testimony and ultimately the position statements on this, because I read it to potentially assert that we are changing the base that we're measuring against, just the way I read the flow of the testimony and the position statement. And I just want to be clear, and I think all parties will agree with this, and it was talked about in openings, we are utilizing the rates that were in effect as of December 6th of 2018, which was the rate case that concluded prior to our adoption of PISA, to measure our compound annual growth rate against. That is what's called for, and that's what we're doing. So if there's any confusion in staff's testimony or in reading staff's testimony on that, I want to make sure that's clear. The difference solely of this case is the perspective of OPC and staff of whether you only look at the effects of the two FAC accumulation periods, the accumulation 29 and accumulation 30, or as we have suggested, you also have to look at the rebase of what's going on in the current general rate case for rates that will be in effect in December. Otherwise, you can't address the full impact that fuel and purchase power costs are having on implications to Evergy Missouri West compound annual growth rate. That's really the only difference in what we're talking about.
Do you agree with the staff witness that the appropriate statutory, or what I used as CAGR, C-A-G-R cap, that cap is 11.6887% for this accumulation period?
Yes, so I'd refer actually to, I agreed with the dates that were laid out in the opening of the Office of Public Counsel. So September 1st of 2021 is the time frame that you would look at it from just the FAC measurement. There were some other dates presented in that opening, and the most important one from the company's perspective is the accumulation that occurs when you get to the December 6th date, which is 4 years post the 2018 base that we're measuring against, and that is the 12.55%. But at September 1st, I agree with the number that's in staff's testimony.
Well, while we're on that point, Mr. Ives, you mentioned the 12.55% would be the date on December the 6th. I believe I heard the public counsel suggest that on December the 1st, just 5 days earlier, it would be 12.51, slightly less than that. Would that make sense to you?
Yeah, I didn't do the math on December 1, but it certainly grows as time progresses forward from the December 6, 2018 base. So there would be a little bit of difference if you move forward from the 6th.
I also understood the counsel to suggest that public counsel would suggest the commission should decide this case by 12/1. And if they decided the case 5 days later, would all of the issues in this case be moot?
Yes, I think it's a very interesting timeline for the commission, and it's part of why we're here, right? When we made our filing for this FAC back in July, rather than, as maybe has been asserted in this case, rather than being manipulative or attempting to pull a sleight of hand, we used the best information available to inform the commission of what was coming. What was coming was the two accumulation periods that had been more significant and persisted longer than anybody had hoped for the amount of market impacts that we were having in fuel costs from Missouri West. In addition, we knew that the general rate case was ongoing. We had seen the direct position of staff in that case. We knew that prices were continuing to go up, so when we got to true up in which was a May 31st true up date, but hadn't been filed yet by the time we filed on July 1. We knew that number was going higher for fuel impacts in the general rate case. And it was very clear that the combination of all those fuel effects were going to put us in a position where we were going to exceed the compound annual growth rate accumulation, or the 12.55% when you looked at all that in combination. That's why we advanced it. That's why we brought it forward. And it has come true. If you look at the commission, which has now issued an order on the settlement agreement that was entered in the rate case, approving that settlement agreement, there is enough of a case impact just based on that settlement, and certainly the fuel impact based on the base factor included in that settlement, that shows, without taking action to create a deferral, that fuel and purchase power cost would drive Evergy Missouri West over the cumulative CAGR. In isolation, fuel and purchase power cost would drive us over that. Without the increase in fuel and purchase power cost, we would not be having a PISA cap discussion at this utility.
Mr. Ives, as you read the testimony and the position statements in this case, is it your understanding that all parties agree that a deferral would be appropriate if it was done in the context of an FAC case where the FAC rates in that case caused the CAGR to be exceeded?
Yes, I think it appears clear to me that people agree with if an impact is occurring in an FAR, an accumulation period, that would take you over a cap, then you would apply the deferrals under 1655.5. That's what it looks like to me reading everybody's testimony. Where we differ, again, is whether or not you believe the commission should consider the part of the FAC requirement to rebase fuel in a general rate case, any general rate case that you file, as long as you are under the FAC and have adopted the FAC. That's the difference. We think fuel is a component in both, and we think fuel means the same thing, whether it's coming through a rebase or whether it's coming through an accumulation period. And between the language in 1655.5, and if you want to take it a step further, between the newly adopted piece of statute that completely recognizes that fuel should not be a part of a cap calculation, it's clear that the intent of the legislature was not to have performance penalties driven by fuel and purchase power cost.
So if the commission has not decided this case until after it decides the rate case, at that point, would the CAGR have been exceeded?
If the rate case were decided first, and there were still no determination on application of the FAR for accumulation period 30, you would be under the CAGR cap until the FAR went into effect. That would take us over, and you would need to defer. Again, I mean, we are arguing about the application of statute to fuel and purchase power. We are asserting that fuel and purchase power is the same regardless of whether it happens in a rebase or whether it happens in an FAR accumulation period. The other parties in this case argue for different treatment for the implications of fuel and purchase power in a rebase.
But do you believe the statutory cap will be exceeded when the pending rate case and the last two FAC accumulation periods are considered?
Absolutely.
Now, on page 4, line 18 of staff rebuttal testimony, the staff witness states the PISA deferral is not required in this case. Do you agree?
No, I don't. I mean, that's why we're here. I think this case is the ideal opportunity to do it. I provided testimony to the commission in the rate case that discusses the complexity of attempting to address a deferral in the general rate case as opposed to the FAC. I'm sure the other parties will say that there's no mechanism to create a deferral in the general rate case. I would suggest that the commission, if they don't address it in this case, really needs to address it as a deferral in the general rate case for all the discussion that I've had today. It's fuel and purchase power cost. The PISA statute is clear that those should not drive a performance penalty. If you do a deferral in a rate case, your likely impact is that it will understate the rebase fuel cost in a general rate case in order to make that deferral. And then you will have higher accumulation period impacts moving forward out of the case, which will create FAR volatility for customers moving forward compared to what it should be if the base is set appropriately. And it'll create exposure to the FAR 95.5 that would not otherwise impact a deferral if you did it in this case now under 1655.5. I want to be clear, the initial amount that gets deferred is reduced for the 95.5 if you deferred in this case. You just don't have an every 6-month impact because of the 95.5 because you've artificially lowered a base if you do a deferral in the rate case.
Mr. Ives, have you prepared an exhibit that shows the cumulative impact of the pending rate case in the last two FAC accumulation periods?
Yes.
And was that one that I showed on the screen but probably couldn't be seen on the internet feed?
Yes.
Judge, at this time I'd like to have an exhibit marked as, I guess it would be exhibit number 3.
All right. Do you have an actual paper copy of that? Okay.
Thank you.
Mr. Ives, I've placed in front of you what's been marked as exhibit number 3. Is this the exhibit that you prepared in anticipation of this case?
Yes, it is. Oh, sorry, yes, it is.
Would you explain what this exhibit shows, what it's designed to show?
Yes, I'll start with the FAC accumulation periods because we've talked about those a little bit. Part 1 is actually the FAC accumulation period 29 that's been referred to in this proceeding. What's listed as Part 2 is the FAC accumulation period 30, which is the period that is it direct issue in this case. And then this table is an update, I would say, from the table that was included in my direct testimony in this FAC proceeding. At the time we did my direct testimony, we didn't have the true-up information and the settlement information and ultimately the commission order approving the settlement in this case. But we did have staff's direct case at that time, so my direct testimony used the staff's direct fuel run to present this information. Here, what I've done is I've used the base factors that were considered in the settlements of both the 2018 and the current rate cases, and done the math to split the effect of the base factors between transmission cost and fuel cost that would be applicable to run through an FAC to give my estimate of the fuel impact that is driven in the rebase of the rates in the current pending general rate case. Those three items together, fuel components only, take you to a 17.2% overall increase, which is intended to show what I answered earlier, which is left unaddressed. Fuel is going to take Evergy, Missouri West above the PISA caps, which is explicitly indicated to not result in a performance penalty in the statutory language. I should share that, the overall revenue requirement that was in the stipulation that was agreed to and ultimately approved by the commission in an early order was $42.5 million. If you replace that number in for the 56, that's just fuel, that line on percentage increase goes to 5.7%, and the overall for the three items goes to 15.37%, which is still above the cap, with the remaining issues that are to be decided by the commission. While they will impact that final amount, there likely is not enough movement in those to impact that final amount to the point that it will be below the compound annual growth rate run rate of 12.55%, but yet to be determined by the commission.
Well, in the pending general rate case, is the rebasing of the fuel and purchase power cost the reason there will be an increase in the rates?
Yeah, certainly it's a full general rate case, so we looked at, all relevant factors, as the commission always would in going through that, but it is a driver, I'll put it this way, it's a driver to the overall revenue requirement increase that in and of itself is bigger than what the revenue requirement increase is going to be for Evergy West. So in isolation, it reflects more than 100% of what the final revenue requirement increase will be.
Well, would you explain the amount of fuel and purchase power that is being rebased in that pending case?
Really quick, I apologize. Can I get a direction to where we're responding to rebuttal testimony?
This is a rebuttal of their position that these rates should not be, that this rebasing should not be included in this case or in the calculation at this point.
That's fine. I'm trying to follow along. I just want to know where in the rebuttal testimony I should be paying attention so I can.
I'll try to get more to the rebuttal too as well, specifically, but.
And again, you'll have the opportunity to cross-examine later.
So just to repeat the question, would you explain the amount of fuel and purchase power that's being rebased in the pending rate case, the total amount?
Yeah, so the incremental increase, and I don't know that I have the total amount of fuel. Well, it looks like, sorry. So the total amount of fuel that I believe is being rebased based upon the base factors in the settlement is on that schedule, the $245,512,953.
And the incremental amount would be the 56.1 million there that you show in the schedule?
Yep, as I mentioned earlier, that's the incremental of when you compare the base factors from what was set in the 2018 case compared to the base factor that has been agreed to and ordered by the commission now for the current 2022 case.
And how much was that settlement amount that's still subject to some adjustment by the commission for contested issues?
The settlement amount overall was the 42.5 million that I mentioned, with a couple of remaining revenue requirement issues that were litigated and await a commission order.
And did you testify already that the commission has adopted an order approving those settlements?
I did.
Okay. Well, if the expected impact of the general rate case is added to the impact of the fuel and purchase power increases from the last two accumulation periods, do you believe the statutory cap of the PISA statute will be exceeded? I think you've already answered that.
I did, yeah, and that's the intention of the presentation on the schedule.
Is it correct that the final impact of the general rate case will not be known until after the commission issues its final report and order in this rate case, in the pending rate case?
That's correct. I mean, maybe just to be very clear about where we're at, right? I mean, the operational law date for the case is scheduled for December 6th. If the commission follows its general practice, they would put out a written order approximately 30 days in front of that. So in the early part of November, which means they probably would have agenda discussion a week or two in front of that. So in the middle part of October, so they will be making that decision right at the same time now that they will be considering the briefs and making a decision in this case. And I think my simple request, that probably is overly complicated by the testimony in the record, is that the commission should look at the big picture and not look at these two dockets in isolation, and they should consider whether or not, as I mentioned, the cap exceedance, which there's going to be one for Evergy, Missouri West, is driven by fuel and purchase power cost or not. And if it is, which the schedule in Exhibit 3 demonstrates that it is, then they should defer the implications of that. If they make the decision to do the deferral after they understand the order in the general rate case, they will know that the amount of the deferral necessary to stay under the cap is not 31 million as we filed. It will be something less, and they can set the deferral. They can ask the parties to calculate, based on their decisions in the case, what the deferral should be, and they can set it as the piece of legislation intends to be just enough of a deferral to stay under the performance penalty cap, but be adequate to do so. I think Mr. Fisher mentioned in the opening that they are currently asking parties to calculate impacts in a proceeding right now in Evergy West securitization proceeding based on positions that they have articulated they want the parties to consider. They could do the same thing here and get the same information available to them to make the best decision in this docket and consider the implications of the general rate case.
Well, I don't want to leave Ms. Mantle's testimony out either, but some of your answers will be relevant to her testimony as well. Is that right?
Yes, that's correct.
On page 15 of Ms. Mantle's rebuttal, she states that the $31 million deferred amount was to maximize the increase that Missouri West could receive in its current general rate case without surpassing the statutory cap. Do you agree with that characterization?
No, I mentioned this earlier. There are some sensational words used in this docket around manipulation and maximizing, and that all sounds exciting for the hearing. But the reality is we use the information available to be as conservative as we could be when we put the July filing together. We knew staff's direct fuel run, which is what we used in the analysis of my testimony, and we knew our original rate case ask, which was the maximum that we could get out of the general rate case. We utilized those factors to discuss the deferral that would be necessary to ensure that the caps weren't exceeded due to fuel and purchase power costs. As I mentioned, by the time we get to mid-October or so here, the commission is going to have made decisions in the rate case and will be able to gather all the information that it needs to determine what the actual deferral should be to not trigger a performance penalty. They can ask parties to calculate it. It will be less than 31 million based on the settlement and the remaining items in the case. And they should ask the parties to set that at the appropriate level to meet the criteria 1655.5.
The public counsel witness also, I think, alleged that the high fuel and purchase power costs are a direct result of its resource planning decisions and not due to external factors. How would you respond to that?
Well, I'd respond to it that it's been a frequent discussion. We've talked about it in the rate case, we've talked about it in the securitization case, and we're talking about it here. I don't think it has any relevance here. The relevance, the place for it, if it were going to come up, would be in a prudence consideration of the amounts underneath the 44 million, not the deferral discussion that we're having today. But that said, I think the commission has heard plenty on that topic, and I think they've answered it at least once, if not more, and I assume they will have the information to answer it again in this case.
I think Ms. Mantle also discussed on page 20 through 22 the differences between Evergy, Missouri's West generation resources and the generation resources of its sister company, Evergy, Missouri Metro. Is that comparison appropriate in your mind?
No, I mean, this is another area where we've had discussions before, right? I mean, Evergy, Missouri West and Evergy Metro have their own resource plannings. They file their own integrated resource plans. They do, just like, same with the difference between Liberty and Evergy, Missouri West, just like the difference between Ameren, Missouri and Evergy, Missouri West. They have different resource mixes, absolutely. There's a lot of history that has come into play over decades that has each of these utilities in a different resource planning spot. And I mean, if the point is they're different, then the testimony makes sense. Beyond that, you know, there's a process to evaluate all that.
Do you agree with staff and public counsel's contention that the cost in this accumulation period are not extraordinary?
No. You know, it's interesting, and I'll address the question that was brought up is, you know, why extraordinary now if not extraordinary in accumulation period 29? It's the persistence of the market conditions. At the time we were in accumulation period 29, we knew there was implications, or had been roughly since Winter Storm Uri. I know I heard counsel say there's absolutely nothing to do in this docket about Winter Storm Uri. I agree with that from the fact that there are no February 2021 dollars in this case. Winter Storm Uri has absolutely had an effect on the prices that are persisting in the market today from a supply standpoint, and prices have been elevated for that, plus many other factors since that time. But now with continued reports out, whether it's from the SPP Market Monitor, from EIA, from other credible industry sources, these prices are high, they're abnormally high, and they are expected to persist for a period of time to be abnormally high. One other thing I would address in the testimony was Well, it can't be extraordinary because it's affecting all utilities. Well, there's where I say Winter Storm Uri affected all the utilities in the Midwest, but somehow it was an extraordinary event. So just because it affects more than one utility doesn't disqualify a set of costs from being extraordinary.
In preparation for your testimony, have you reviewed reports in the industry about the extraordinary natural gas prices and wholesale prices that have occurred during this period?
I'm sorry, I mentioned those just a minute ago in regards to my response about extraordinary. There's a recent SPP Market Monitor report that was issued in July. There's certainly some EIA reports that continue to be updated and put out on a monthly basis. There was one for August, and I believe there's one out for September now. A long story short is a lot of discussion about the extraordinary impacts on natural gas prices and power prices of the current supply constraint issues that have persisted since Winter Storm Uri, have persisted during the hot summer, have persisted as the war in the Ukraine has gone on and put stress on the world markets. A lot of factors in a lot of reports across the industry that lead to discussion of these being extraordinary fuel and purchase power times as opposed to just a run-of-the-mill, it's what everybody is incurring.
We're almost done, Mr. Ives, but on page 28 of Ms. Mannel's rebuttal, she alleges that if the commission approves the company's deferral request, the PISA rate caps will be rendered meaningless. Do you agree with that?
No, I entirely disagree with that. I think the PISA statute pretty clearly says that the implications of rate adjustment mechanisms, such as the fuel adjustment clause, shouldn't drive to performance penalties on PISA caps. The PISA caps should consider the effects of what's going on as a result of implementing and adopting PISA, which is making incremental investment in the state, in the utilities, and the implications of doing so. They're not meaningless. They'll still be there and operating to cover the costs that they were intended to address, which is even further bolstered by the updated legislation for PISA that makes that very specifically so. But the in effect legislation for this time, nonetheless, is still very clear that fuel and purchase power cost should not have implications to that compound annual growth rate.
Well, just so the record is clear, what were those PISA caps? What kind of costs were those intended to address?
Well, in general, they were put in place because the legislation provides for an incentive for the utilities in the state to invest in needed infrastructure improvements for the service to customers, including the ability to add grid modernization and add investments. That's what the legislation is entirely intended to address, and it provided a cap framework to make sure that that was being done responsibly and in a way that wasn't going to overly burden customers. The cap certainly addresses all components of rates to customers in the current in effect PISA legislation, but has the allowance in the 1655.5 to ensure that the effects of fuel and purchase power through a rate adjustment mechanism are not considered in exceedances to those caps.
Since the company elected PISA in 2018, what percentage of the increases or changes in rates that have occurred would be due to fuel and purchase power?
With the consideration of Exhibit 3, over 100% will be due to fuel and purchase power.
Okay, now based on the most recent information available from the rate case, which I'm talking about the settlement and the true-ups, what is your current best estimate of the amount of fuel and purchase power costs that will need to be deferred in this case to prevent the company from breaching its statutory cap and to minimize the amount of the fuel and purchase power costs that are deferred in the PISA regulatory asset?
Yeah, I hate to have to do this again, but once again, this is way outside the scope of what anybody said in rebuttal. I mean,
Being a member of the GAP.
All right, someone needs to mute.
This is in response directly to their position that all 31 million should be deferred.
where in testimony is that question responding to?
That's responding to direct testimony of staff witness that the deferral should be 31 million.
First of all, there is no direct testimony of staff witness.
I'm sorry, rebuttal testimony. You're right.
Mr. Kleiser, I'm going to overrule your objection and allow it.
Yeah, so I alluded to this earlier anyway. I just didn't give the value, but I said that the deferral would be less coming out of the rate case than the way we calculated the 31 million at the time we made the July filing. So this will hopefully help put some scope to that. If you just looked at the Exhibit 3, you replaced the 56.1 million with the 42.5, and you looked at what the differential would need to be. We would need about $11 million deferral to stay under the PISA caps as a result of 1655.5. If you went on from there and you considered Evergy's positions on the remaining issues that the commission's litigating, so if we prevailed in the positions that we advanced, that number would move to a need for deferral to about $19 million. So to do the deferral right, getting the final information from the commission order, identifying the amount that's necessary to just keep us under the cap due to deferring fuel and purchase power cost, and not have an exceedance of the 3% compound annual growth rate, that 31 should likely be in the range at conclusion of the commission's order, somewhere between 11 and 19 million.
Is it correct you won't know the exact amount until the rate case order has been issued?
That's correct.
If the commission accepted the recommendations of staff and public counsel in this case, what could be the financial impact upon Evergy, Missouri West?
Yeah, so I talked about this a little bit in the rate case testimony as well, but that range I just gave, that 11 to $19 million, if you at least take the Office of Public Counsel's position that when you get to the rate case, that would be a performance penalty. That means we would not have the opportunity to recover 11 to 19 million dollars that otherwise would be demonstrated to be appropriate to be ordered out of the rate case by commission order, and it would be solely because we have had extensive impacts from fuel and purchase power. So that's the easy, direct answer if you go all the way to penalty provision. If you don't do a deferral in this FAC case, but you determine that the impacts in the rate case are a result of fuel and purchase power and the commission wanted to make a deferral in that case, it gets more complicated, but I think you would defer by reducing the rebase cost in the rate case to stay under that cap, that same 11 to $19 million. But then what happens is you're having larger FAR accumulation period impacts coming out of that case because you've artificially lowered the rebase amount. And the impact of that would at least be 5% of every 6-month accumulation period times that $11 to $19 million would be an impact to the company that you wouldn't have if the commission makes a deferral in the FAC proceeding.
Judge, with that, I think that's the last of the questions I have on Sir rebuttal. I would move for the admission of exhibit number 3, and I would tender the witness at the appropriate time for cross-examination.
All right. Are there any objections to the admission of Exhibit 3? All right. Hearing none. Mr. Fisher, do you have that exhibit in electronic form?
I can certainly email it to you in the exhibit web box or whatever it's called, yeah. I'd be happy to do that.
The email address is exhibits, plural, at psc.mo.gov.
I can send that to you and all the parties.
All right, thank you. All right, let's, all this talk about Kegers makes me want to take a break. So let's take a break and we'll reconvene at 10:45. All right, I am not sure that I admitted Exhibit 3, so if that was the case, then Exhibit 3 is admitted. And Mr. Fisher, Mr. Steiner, do you have any other witnesses?
No, Judge, that's all we have.
All right, at this time. All right, Ms. Aislinn, call your first witness.
Staff calls Brooke Mastrogiannis.
Hey, Judge, this is Commissioner Roop. I just wanted you to log my presence in on the hearing.
All right. You are on the recording. All right, would you raise your right hand, please? Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
Please state and spell your name for the record.
It's Brooke Mastrogiannis. That's Brooke with an E. Mastrogiannis.
How are you employed and in what capacity?
I am employed with the Missouri Public Service Commission, and I am a utility regulatory audit supervisor.
Did you prepare rebuttal testimony for this case marked as Exhibit 100?
Yes, I did.
Do you have any changes or corrections to that testimony?
I do not.
If I asked you the questions contained in that testimony today, would your answers be the same?
Yes.
And are those responses true and correct to the best of your knowledge and belief?
Yes.
Staff moves for the admission of Exhibit 100.
Are there any objections? All right, hearing none, Exhibit 100 is admitted.
And Ms. Mastrogiannis does not have any sir rebuttal.
All right, then you are excused.
Okay.
Do you have any further witnesses at this time? Okay. Mr. Kleiser, call your first witness.
The OPC would call its only witness, Ms. Lena M. Mansell.
All right, Ms. Mantle, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you.
Ms. Mansell, could you please state your full name and spell your last name for the record?
My name is Lena, Lena M. Mantle, Mantle.
And by whom are you employed and in what capacity?
I'm employed by the Office of the Public Counsel as senior analyst.
And your contact information can be found in your testimony that was filed, or that has been pre-filed in this case, correct?
Correct.
Which actually leads me to my next question. Did you prepare or cause to be prepared testimony for this case that has been pre-marked Exhibit 200, the rebuttal testimony of Lena M. Mansell?
Yes.
Do you have any corrections you would like to make to that testimony?
No.
And if I were to ask you the same questions that were posed in that testimony today, would your answers be the same or substantially similar?
Yes,
And are those answers true and correct to the best of your knowledge and belief?
they are.
All right. Your Honor, at this time, I would move to admit Exhibit 200, the rebuttal testimony of Lena M. Mansell, P.E.
Are there any objections? Hearing none, Exhibit 200 is admitted.
I'm going to proceed through sir rebuttal.
Go ahead.
Ms. Mansell, on page 5, lines 16 through 18, Ms. Mastrianis states that Ameren, Missouri, and Liberty have also experienced increased fuel and purchase power costs. Do you agree with her?
Yes, and so has Evergy Metro, Evergy West sister utility. All utilities have seen higher fuel and fuel prices, which in turn have driven up energy market prices.
Has any other Missouri utilities included a future rebasing of fuel and purchase power costs in their calculation of an overall average rate increase for the
No.
FAC?
No.
Ms. Mastrianis on page 6 of her rebuttal, lines 6 through 16, reminds the commission that if the commission deferred $31 million as Evergy West is requesting, it could be up to 4 years before this deferral is included in rates. What would the regulatory asset amount for this $31 million be if it is 4 years until new rates are effective?
If given PISA deferral treatment, the $31 million would accumulate interest at 8.25%. And in the next rate case, that amount would, if it was at 4 years, the amount would be $42.6 million that would be included in the next case. It's the amount that would be recovered, and it would also generate a profit for shareholders.
And how would it be recovered in the next case?
My understanding of the PISA statute is that it's deferred, or it's recovered over 20 years at the weighted average cost of capital, which is what capital costs typically earn. This is an expense, but it too would earn 8.25%. That's my understanding of how that would be treated in the next case.
And what would the total amount paid by customers for this deferral if it is recovered over 20 years with a weighted average cost of capital of 8.25% be?
By the end of the 20 years, which could be as late as 2046, so people in 2046 would still be paying for this $31 million. The full price that would be recovered for this $31 million would be between $79 million and $85 million.
Did you prepare a exhibit to demonstrate the math for that calculation?
Yes, I did.
Your Honor, I'd like to mark an exhibit. It should be 201. I will hand out copies now.
And I'll wait till you get back to your table. All right, Mr. Kleiser, we spoke a bit at the bench. Is that exhibit something that you can email?
I can email this exhibit, yes. I cannot do it from where I'm sitting. I will need to go back to my office, but I will email it to you at the earliest possible opportunity.
All right. And to the exhibits at psc.mo.gov?
Exhibits at psc.mo.gov.
All right, thank you.
Ms. Mansell, this is the exhibit that supports the testimony you just gave regarding the amount that would be recovered over the 20-year period at 8.25%, correct?
Well, you didn't give me a copy. Yes, it is. I labeled it LMM-S-1. The top part of that, the table here is the 20-year cost recovery with the rate case that cost is put in being 4 years out. I calculated it as if there would be annual rate cases, and that amount can be seen in one of the dark squares as $79.4 million. That would be the total cost, the $42.5 million, and then 36 million, almost 37 million in interest that would go to Evergy. Below that is a calculation as if there were rate cases every year or every 4 years, and the second box with the 84.7 million is the sum of what customers would pay across if there was rate case every 4 years.
If I understand correctly, then deferring this amount would more than double the cost ultimately recovered from customers.
Yes.
What would be the impact if the commission just delays the recovery until the next FAC rate case change as recommended by staff?
That can be seen on that same exhibit and labeled deferral to next FAR. And what I used there was, with the FAC, the short-term interest rate is used. I took the last, short-term interest rate that I could find, I think was, it was 0.11. That would be a monthly interest rate. So it's about a little over 2% annually, as compared to the 8.25 that it would receive under PISA deferral. And so I applied that amount, the 0.11%, over, looks like 5 months, to get 31.17 million. And that's what staff is requesting. They're saying if it is deferred. That is not their position. Their position isn't that it should be deferred, but if it is, it should be deferred until the next FAC rate change case.
I think you might have used a double negative there. So just to clarify, what is your understanding of staff's position?
If the commission says an amount should be deferred, that it should be recovered in the next FAC rate change case, which should be filed in February, I believe, January. Brooke told me January. So that amount would earn interest at the short-term interest rate, which is a lot less than the weighted average cost of capital.
All right, and while the OPC's position is that there should be no deferral, would you agree with staff in the event a deferral is ordered, that is how it should be treated?
Yeah. Of the alternatives, yes. When you put it in the next FAR filing, that's fuel adjustment rate filing, there's likely to be an amount that's as large as what we are seeing in accumulation period 29 and 30. So it's very likely that with the next FAC rate change case, there will be a deferral. And that would be greater if this 31 million was included.
All right, I believe that concludes our surrebuttal, although I would offer Exhibit 201, which was the schedule developed to support surrebuttal.
All right, and it does not have any kind of heading, but it does. Is it fair to say that it's showing PISA deferral treatment and deferral, and then also deferral to the next FAR?
Yes, that is what's on that.
Okay. All right. Are there any objections to the admission of that document? All right. Hearing none, Exhibit 201 is admitted.
All right, as that has concluded surrebuttal, I would, at this point, I guess tender, but I suppose that's waiting.
Yes. Thank you, Ms. Mantle. All right, so we're at the point where the commission would like to make those witnesses that have testified earlier available for cross-examination. Mr. Ives, would you take the stand again? Thank you. And you are still under oath. Is it Aislinn or Aslin?
Aslin.
Aslin. Ms. Aslin, go ahead.
I have no questions.
All right. Mr. Kleiser.
Only briefly, I believe. I always have to check. Good morning, Mr. Ives.
Good morning.
You testified on Sir rebuttal very briefly, kind of related to your interpretation of the statute in question, and I appreciate that obviously the parties have a different interpretation of that. Just out of quick question, you're not an attorney, correct?
I am not.
Are you familiar with the canons of statutory interpretation?
I'm sorry, I missed that word. Can you say it again?
Are you familiar with the canons of statutory interpretation?
I am, without being an attorney, I am generally familiar of the concept, and I would just say, even though I'm not an attorney, I am responsible as the Vice President of Regulatory for at least making policy determinations and interpretations for Evergy, in consultation, obviously, with my legal team, but.
So are you familiar with the phrase expressio unis est exclusio ulterius? And I'm probably mispronouncing the Latin there a bit.
You probably are beyond my scope of Latin.
Or also known as the negative implications canon?
I've heard of it.
Did you apply that in making your interpretation?
You know, I obviously did not interpret this thing on my own. I worked with my legal team and with folks in the regulatory department, and you know, we obviously will brief our rationale for why we believe what we believe on that interpretation.
Thank you. I have no further questions. Thank you.
Thank you.
All right. Are there any questions from the commissioners? All right, hearing none, I have a few questions myself. Mr. Ives, you're familiar with the term force majeure,
I am.
and it is in the statute, correct?
It is.
Has the commission approved a force majeure event for the period of December 2021 through May 2022? In other words, that accumulation period 30 in the general rate proceeding?
No, I'm not aware of the commission approving a force majeure event.
So that, did force majeure come up at all in that general rate proceeding?
I would say there was very little discussion of this topic beyond my testimony in that case.
Okay. And I'll direct your attention to exhibit number 3, the table that you
Yep, thank you.
testified to earlier. So the percentage increases in that far right column, are those actual compound, are they CAGRs, are they compound annual growth rates, or is it some traditional calculation of a percentage increase?
Yeah, so that's a great question. Let's start with the one that's in the box at the bottom, the 1255. That is what I would call the traditional compound annual growth rate calculation, moving from our December 6th, 2018 case to December 6th of 2022. So 4 years of growth of that 3%, as called for by the PISA statute. So that's the limitation, if you will. When you go to the percentages that are across from the other 3 numbers, those are calculated off of a denominator of total revenue that was in effect at the time we adopted PISA. So the total revenue component of the 2018 base level. So there'll be some slight nuance for differences in usage when a final cap calculation is done, when we have final numbers from the conclusion of the general rate case. But by and large, this is a pretty close approximation by using that 2018 total revenue number.
Okay. Is it possible, would it be possible to provide as an exhibit for the commission this table with showing the formulas for these different amounts and percentages?
Yes, yeah, we can show that detail and make sure it's clear.
Okay. All right, I don't have any further questions. Ms. Aslan, do you have any follow-up questions?
No, thank you.
Mr. Kleiser? Any redirect?
Judge, I have no questions. Thank you.
All right, that's Mr. Fisher for the sake of the record. And just to make sure I cover all the bases, any questions from the commissioners? All right, hearing none. Mr. Ives, thank you.
Thank you.
Judge, this is Mr. Steiner. The late filed exhibit you discussed, do you have a date you want that? I'm just, I think we understand what you're wanting. We just want to know.
How about, well, you tell me, how long do you think you need?
Are
Are you looking at a clock or a calendar?
I'm looking at my people that might be creating it. Let me just confer with them just for a second.
Sure.
Thanks, Your Honor. Could you just Wednesday of next week, would that be okay?
I think that'd be perfectly fine. And
Should I call that Exhibit 4?
yes, please. And as far as, do the other parties need an opportunity to object to that, or?
I would request the opportunity, although I don't expect to object.
Okay. Then how about objections within 24 hours of the filing?
That is doable.
Okay. All right. And staff witness, Ms. Mastroiannis?
Yes.
She is on the stand for cross-examination, and you are still under oath. And so, Mr. Kleiser, do you have questions for the witness?
I do have a few. Do you happen to have a copy of Ms. Mantle's testimony?
Yes. The rebuttal in this case.
There's only the one, yep. Can you turn to page 5?
Okay, I'm there.
So on page 5, between lines 9 through 19, Ms. Mantle has included a section of statute. That would be 393-1655.3. Do you see that?
Yes.
Now, earlier today, when Mr. Ives took the stand, he expressed that it was explicitly stated in the statute that fuel and purchase power costs were not to be considered in determining whether or not there was a performance penalty. Do you recall that?
Yes.
Can you tell me, is the words fuel and purchase power found in that section of statute?
I do not see those words.
Would you agree with me that the statute in general only speaks to the difference between the electric corporation's average overall rate and the rate that was in place at the last case immediately prior to the election of PISA?
Yes, that's my understanding.
And you would agree with me that fuel and purchase power costs would be part of a company's overall average rate?
Yes.
If you flip the page over to page 6, there's 393-1655.5. Do you see that?
Yes.
And would you agree with me once again that if I were to read through that section of statute, the words fuel and purchase power do not actually show up?
They don't show up, but it does mention section 386.266.
Well, that's okay. I'm going to get into that in a second.
Okay.
But you agree with me that they don't show up, those words don't show up in that statute?
Correct.
All right, so let's talk about 386.266, since you mentioned it. You would agree with me that that's the provision of the statute that allows for recovery of what is commonly known as the fuel adjustment clause.
Yes.
I can't remember exactly what it's called in the statute. Now, the fuel adjustment clause, you would agree with me, allows a company to recover the difference between actual fuel and purchase power costs incurred and what is included in base rates, correct?
Correct.
You would agree with me, therefore, that there is an amount included in base rates that is not included or recovered through the fuel adjustment clause, correct? For fuel and purchase power. Let me rephrase that to make sure it's clear. I apologize. You would agree with me that there is an amount of cost for fuel and purchase power that is included in base rates that would not be recovered directly through the fuel adjustment clause itself, correct?
It's just the difference between the two.
And you would agree with me that if the legislator wanted to ensure that all future fuel and purchase power costs were considered in the determination of this provision of statute, they could have identified all fuel and purchase power costs, correct?
Correct.
I am sorry. Whoops. Now, earlier today, Mr. Ives testified about the idea of persistence and how that factors into determining whether or not something is extraordinary. Do you recall that general conversation?
Yes, I recall.
Would you agree with me that at a certain point, if something persists long enough, it's no longer extraordinary?
Can you rephrase that question?
Probably. Give me 1 second.
Okay.
Let me think it through. The longer cost persists, the more normal it becomes and less extraordinary it is considered.
Yes, I would agree with that.
Let's consider, for example, the situation in the Ukraine. Have you followed the Ukraine-Russia war at all?
Not very, I mean, not fully. I'm aware of it.
Are you aware of any reason to assume that it's going to end anytime soon?
No, I would not know the answer to that.
If it were to continue for, let's say, several years, would you believe that the cost impact of that war was extraordinary for several years?
No.
Is it extraordinary for economic cycles to occur that include inflationary trends up and down?
Can you ask that again?
Is it extraordinary to expect that world economies would shift and that inflationary pressures could go either up or down?
No.
Based on your testimony, you do not believe that the fuel and purchase power costs, let me be specific, that were incurred by Evergy West during the 30th accumulation period would be extraordinary, correct?
Yes, I do not believe they're extraordinary.
I believe that is all of my cross. Thank you.
All right. Mr. Steiner, Mr. Fisher, do you have any questions?
Mr. Fisher, for the record, if the company is about to exceed the statutory cap under PISA due to the operation of a rate adjustment mechanism approved by the commission, is it your understanding the company is required to defer an amount of fuel and purchase power into a regulatory asset to keep from exceeding the statutory caps under the PISA statute?
It is my understanding that if you look at section 393.1655 subsection 5, if they hit the cap in the rate adjustment mechanism like the FAC, then yes, they would defer those costs into a regulatory asset. But in this scenario, they are not hitting the cap in the FAR.
And that's because the commission hasn't issued the rate case order, right?
That's correct. It wouldn't be issued till, the effective date would not be till December 6, 2022.
Would you agree that the company and other parties to the pending rate case will not know the exact amount of the rate increase from the rate case until the commission decides the contested issues?
I would agree with that.
Are you aware the staff has entered into a stipulation suggesting a $42.5 million increase would be appropriate for West with some adjustments depending on how the commission rules on the contested issues?
Yes, I'm aware.
The final rate increase may be somewhat more or somewhat less than that's been stipulated between company staff and public counsel in that rate case, right?
Yes, it could be more or less.
If the commission issues an order in the rate case resolving the contested issues, do you agree that the parties would be able to calculate the amount of the deferral of fuel and purchase power costs that would be necessary to keep the company from exceeding the cap in the PISA statute at that point?
If this case were to be determined first, then yes, there would be a way to calculate it.
No, I think it wouldn't be backwards. If the rate case is determined first,
Yes, sorry, that's what I meant. If the rate case would be determined first, then yes, they
then,
would.
then you would be able to calculate the amount of deferral that would be necessary to keep the company from exceeding the PISA statutory cap, right?
And let me make it clear, I probably would not be calculating that, but yes, someone within staff would have to.
Sure, okay. And staff would not have a problem at that point in recommending a deferral if it was about to exceed the PISA cap, right?
Well, our problem is that this case should be determined first because the effective date of rate should have been September 1st of 2022.
I'm not asking you that question. I'm asking you if the commission issues the rate case order and this case has not been decided, at that point, it would be under the FAC rate mechanism, correct? And you would not have a problem with a deferral, is that right?
If that were the scenario, then staff's position is that the amount would be deferred to the next fuel adjustment rate filing. Now,
On that point, do you agree that the PISA statute, which is 393-1400, does address how a regulatory asset or how a deferral is treated into a regulatory asset?
I'm generally aware of it.
Okay, and that does address that topic, correct?
Can you state that question again?
Yeah, sure, it was unclear. I'm asking, you're aware that there is a statute, 393.1400, that addresses how a regulatory or how a deferral would be treated into a regulatory asset, correct?
I believe so, yes.
Okay, that's all the questions I have. Thank you very much.
Do the commissioners have any questions? All right, hearing none. I have a couple of questions. Let's see. If we go back to accumulation period 28, did you contribute to staff's recommendation and the memorandum that accompanied that recommendation that was filed on August 2nd, 2021? The Evergy, Missouri West FAC filing for that accumulation period, which would be the PSC file number ER-2023-0011.
I'm not sure if my name was on that, but I do know I contributed to it.
Okay. And if you recall, well, do you recall, did that recommendation recommend using a 3-year February average baseline in place of actual February 2021 fuel and purchase power costs because of Winter Storm Uri?
Yes.
Okay. Would staff be willing to provide that recommendation as an exhibit in this case?
Yes, we can do that.
Okay. And, let's see. That would be Exhibit 101, correct?
Correct.
All right, thank you. And for the record, that's Ms. Aslin. Also, Ms. Aslin, Ms. Mastroiannis's rebuttal testimony has a schedule BMM-R3, and on page 7 of that schedule, which would be the second last page of what was filed, there is a reference to an attachment A that includes 3 charts providing a summary of Evergy, Missouri West, I assume speaking of accumulation period 30 FAC rate adjustment filings. There is not an attachment A filed. Is that something that can be filed to complete that rebuttal testimony filing?
Yes.
I didn't know what to call it. All right, thank you. All right, Mr. Kleiser, do you have any follow-up questions on my questions?
No, I don't.
Okay. Mr. Fisher?
No, thank you, Judge.
All right. Any redirect?
Just a couple questions. Do you recall counsel for Evergy asking what staff would recommend if the rate case order was issued before an order in this case?
Yes.
And what do you state that staff's recommendation would be in that instance?
If that were the instance, then if timing were the issue, then staff's recommendation would be that this deferral of the 31 million would be included in the next fuel adjustment rate filing.
Is that staff's recommendation in this case?
No, it is not.
What is staff's recommendation in this case?
Staff's recommendation in this case is to include the full fuel and purchase power adjustment in this FAR filing for AP 30.
Okay. Thank you. No further questions.
All right. Mr. Kleiser, any follow-up? No. Mr. Fisher?
No, thank you.
All right, thank you.
Thanks.
All right, Mr. Kleiser, is Ms. Mantle available for cross-examination? All right. And Ms. Mantle, you are still under oath. So, Ms. Aslin?
No questions.
All right. Mr. Fisher?
No, thank you, Judge.
All right. Do the commissioners have any questions? All right. Hearing none, I have some questions. When it comes to extraordinary costs, does the commission typically consider extraordinary costs in accounting authority order requests?
That is the typical for extraordinary cost, yes.
Has the commission set any criteria for the financial impact that an extraordinary event should have on the utility's financial position?
I believe the USOA, Uniform System of Accounts, may have a guideline, and there has been a percentage of revenues applied, but that is not consistent. The commission has I started with the commission in '83, and I can't say I'm familiar with every AAO since then, but The guidelines the commission goes by varies from instance to instance.
When it comes to force majeure versus extraordinary, in your opinion, or in public counsel's opinion, what is the difference?
And if I remember correctly, the PISA statute talks about how force majeure should be handled. Force majeure could be the reason that a accounting authority order was issued or granted. I don't ever remember the commission declaring a force majeure. Typically, it's a supplier or that states there's a force majeure is what I've seen mostly. I do not recall the commission ever stating there was a force majeure.
All right. Excuse me. Could I direct your attention to page 24 of your rebuttal testimony?
Okay.
You refer to an interest rate of 8.25% for the PISA deferral. What is the source of that percentage?
The source of that is the stipulation and agreement in the current case ER-2023-0011. It was part of the stipulation and agreement.
Okay. And then you go on to state the interest rate for extraordinary costs would be set by the commission and could be as low as 0. What do you mean by that?
These costs are expenses. They do not typically earn a return for the utility. And in that case, the interest rate is 0. That would be very unlikely. I believe our office would recommend an interest rate comparable with the bond rate for the length of recovery. So if a recovery was set for 4 years, it'd be the interest rate of a 4-year bond. Recognizing that, wanting to keep the company whole, but also preventing shareholders from earning a return, which the 8.25 provides a return for shareholders. We do not believe shareholders should earn at customers' expense for an extraordinary expense.
All right. Ms. Aslan, do you have any follow-up questions?
No, thank you.
Mr. Fisher?
No, thank you, Judge.
All right. Mr. Kleiser, any redirect?
Hopefully brief. All right, you were just having a conversation with the judge regarding the interest rate for an extraordinary expense. I want to make sure the record is clear here. Your position is that these expenses are not extraordinary, correct?
That's correct. They can flow through the FAC without hitting the cap set by PISA, and they are expenses that are less than the previous accumulation period. There's been nothing shown that shows me that these were extraordinary costs.
All right, so let's assume, though, for the sake of argument, the commission does allow a deferral basis that they're extraordinary, not because of the PISA statute, but because on the basis they're extraordinary. Are you following me so far?
Such as with an AAO request, a request to put it in a regulatory liability account?
Effectively. But that the commission allowed for staff's proposal that they were recovered in the next FAR.
Judge, I think I'm going to interpose an objection. I think that's going beyond the scope of any question from the judge.
I will get straight to the point. My question has to do with...
Overrule.
Oh, sorry.
Yeah, go ahead.
Well, you had mentioned a 4-year bond interest rate. My entire point was, if it was going to recover to the next FAR, how quickly would the recovery be?
It would be 12 months, and until that went into the FAR, it would only accumulate interest at the short-term interest rate as set out by 386-266 for FAC cost.
Right, that was my only question there. The only other question I had, when it comes to extraordinary costs, you were asked a question from the bench about when it comes to extraordinary costs, do you look at an AAO, for example? Do you recall that line of questioning?
Yes.
Now, the FAC statute itself has a provision that requires the company to identify extraordinary costs being deferred as part of its filing. Do you recall, or are you all familiar with that?
The statute does not have a provision. The Commission's FAC rule has a reporting condition that if there was extraordinary costs that were not included in the FAC, that the company should report that to the Commission.
And did the Evergy West report these costs as extraordinary pursuant to that rule?
No, they did not.
All right, that was my only question. Thank you very much.
All right. Ms. Haslund, any follow-up questions? Ms. Fisher?
No, thank you, Judge.
Thank you. All right, I believe you're excused.
Judge, this is Mr. Steiner. I think you have a late file exhibit from staff coming. Could we have the same 24 hours to provide an objection if we so deem?
Yes, yes. I was actually, that was going to be my next question.
Thank you.
And I'll ask you, Ms. Haslund, when do you anticipate getting that filed?
Tuesday at the latest.
All right. So there are those two exhibits that are pending, but just to kind of go through, for Evergy, Missouri West, Exhibits 1 and 2 are admitted. Those are the direct testimony of Darren Ives and Lisa Starkebaum, respectively. Staff Exhibit 100, the rebuttal testimony of Ms. Mastro-Ianis has been admitted, and Public Counsel's Exhibit 200, the rebuttal testimony of Ms. Mantle has been admitted, as well as Exhibit 201, which is the table that includes many numbers.
Judge, this is Jim Fisher. I think Exhibit 3 I have now provided that electronically, as you suggested. I believe that was also admitted.
That is correct. I apologize. It is actually Exhibit 4 that has not yet been offered and admitted. And that is the table, which is Exhibit 3, but showing the formulas that support those numbers in the table.
Your Honor, I have one question for you. Regarding the Exhibit 201, which I'll provide electronically as soon as I get back upstairs, its current format is Excel, which is the native format which it was developed in. I believe, my understanding is that Excel files can be uploaded to EFIS. My intent was to provide a copy to all parties in its native Excel format, unless you believe it needs to be sent out as a PDF or otherwise.
Just submit it as an Excel, and if I hear from the data center that that's not acceptable, I'll have you convert it, or perhaps they can convert it. So. All right. Are there any other matters that need to be addressed before we adjourn?
Just one, I have one, I think. I apologize if it was addressed and I missed it, but the matter of transcripts, have we set a date for transcripts?
Right, transcripts, I'll say the goal is to have them filed a week from today, so on October 7th. And then initial briefs would be due by the following Friday, October 14th, and then reply briefs by October 21st, and proposed findings of fact and conclusions of law also by October 21st. So, anything further? All right. Then this evidentiary hearing is adjourned, and we're going off the record.